Welcome to another installment of Your Legal Minute-ish. I'm your host, attorney Michael Goldfarb of Guardian HR, and today we're talking about non-disclosure agreements commonly used in the workplace. The issue with non-disclosure agreements is that there are multiple exceptions to these contracts, and that's what we're going to cover very quickly. So the Dodd-Frank Act, specifically Section 922 of that act, allows employees to report suspected violations as whistleblowers of the Securities and Exchange Commission rules. The same thing applies under the Security and Exchange Commission Rule 21F-17A, and it's important if you're connected to industries affected by the Security and Exchange laws to know that. Another law is the Defend Trade Secret Act, the DTSA, and again, this prohibits retaliation or enforcement of these agreements when an employee is a whistleblower and reporting things to either a federal, state, or local government official for purposes of reporting suspected violations. HIPAA is another area that is not necessarily applicable to these non-disclosures. Another one are OSHA violations. So suspected violations of safety issues at a workplace, you can't prohibit an employee from disclosing that using these agreements. Two really big and hot button issues for employers is the NLRA, the National Labor Relations Act, and its provision against restricting concerted activities. That's where employees want to discuss workplace conditions. These non-disclosure agreements can't restrict that right. Newly enacted are these state and federal laws prohibiting employees from not disclosing retaliation issues and other claims surrounding sexual harassment and discrimination. Bottom line, NDAs are good. Know how to implement them. Be consistent. At Guardian HR, we can help you do all those things. So remember, with Guardian HR support, you stay out of court. Thanks, everyone.